by table of contents, definition and purpose. Legal basis and table of contents, definition and purpose. Legal basis and mandatory thresholds. Why it matters. The 4-point readiness determination. The remaining business of the conference. Attendees and quorum. Step-by-step procedure. The complete readiness checklist. By administration and the threshold nuance. Applicability by mode of procurement. Virtual and electronic conduct. 10 common audit observations, and closing. This is an important requirement to check during a compliance review. Next slide. What this reference covers. This reference is a single, comprehensive treatment of one topic, the pre-procurement conference. It draws together everything relevant to that one meeting, its legal basis, its purpose, who attends, what gets checked, what documents back up the check, how it applies or does not apply, to force account projects and to different modes of procurement, how it may be conducted virtually, and the audit findings it most commonly generates. Every citation has been checked directly against the full, official text of the implementing rules and regulations of Republic Act No. 12,009, and against the DPWH Department orders and COA issuances referenced throughout. Next slide. Section 1. Definition and purpose. What the pre-procurement conference actually is. In the government's own words and in plain terms. Next slide. Section 1.1. Definition. The pre-procurement conference is an internal meeting convened by the Bids and Awards Committee before the publication of the invitation to bid or request for expression of interest, to formally confirm that a specific procurement project is technically, financially, legally, and administratively ready to be exposed to the public bidding process. It is, functionally, a final internal quality check. A structured, documented moment where the BAC pauses and asks, in a disciplined way, whether everything that should already be finished actually is finished, before the point of no easy return, which is publication. Next slide. Section 1.2. Legal basis, the BAC's function to conduct it. Legal basis, IRR of RA number 12,009, Section 42. 1. C. The BAC shall have the following functions. C. Conduct pre-procurement and pre-bid conferences. Government personnel should follow this provision closely to avoid procedural defects. Next slide. Section 1.2. Why this placement in the law matters. Section 42. 1. C. Places the pre-procurement conference among the BAC's core, enumerated functions, in the same list as determining bidder eligibility, opening bids, evaluating bids, and conducting post-qualification. It is not an optional courtesy the BAC may choose to perform. It is one of the specific duties the law assigns to the BAC as an institution. This is worth noting because it means a BAC that never conducts a pre-procurement conference for any of its qualifying projects is not merely adopting a lighter internal practice. It is failing to perform one of its statutorily assigned functions. Next slide. Section 2. Legal basis and mandatory thresholds. The exact peso amounts that make this conference mandatory. Rather than optional, this rule is often a point of focus when verifying compliance with the law. Next slide. Section 2.1. Legal basis, the mandatory rule and its thresholds. Legal basis, IRR of RA number 12,009, Section 49. 1. Prior to the publication of the invitation to bid or request for expression of interest, the BAC is mandated to hold a pre-procurement conference on each and every procurement. However, the holding of a pre-procurement conference is optional for procurement of goods costing 5 million. 00 pesos and below, procurement of infrastructure projects costing 10 million. 00 pesos and below, and procurement of consulting services costing 2 million. 00 pesos and below. Next slide. Section 2.1. The three thresholds at a glance. Project type, mandatory above, ABC, optional at or below, ABC. Goods, more than 5 million Philippine pesos, 5 million Philippine pesos and below. Infrastructure projects, more than 10 million Philippine pesos, 10 million Philippine pesos and below. Consulting services, more than 2 million Philippine pesos, 2 million Philippine pesos and below. Next slide. Section 2.2. Reading the default rule correctly. Notice the structure of Section 49. 1. The default rule is that the conference is mandatory for each and every procurement, and the 3 thresholds are carved out as the exception, where it becomes merely optional. A common misreading treats the thresholds as if they were the starting point, with the conference mandatory only above them. The law is actually the other way around. Mandatory by default, optional only below the stated figures. Even where the conference is optional under these thresholds, a BAC may still choose to hold one, consistent with the same spirit found in Section 51. One's analogous rule for the pre-bid conference, where any prospective bidder may request one in writing, subject to BAC approval. Next slide. Section 2 Observation. Common Audit Observation. Issue 1. Mandatory pre-procurement conference skipped above the threshold. A procurement with an ABC above the applicable threshold, 5 million for goods, 10 million for infrastructure, or 2 million for consulting services, proceeded directly to publication of the invitation to bid without any pre-procurement. Table of contents. Definition and purpose. Legal basis and mandatory thresholds. Why it matters. The 4-point readiness determination. The remaining business of the conference. Attendees and quorum. Step-by-step procedure. The complete readiness checklist. By administration and the threshold nuance. Applicability by mode of procurement. Virtual and electronic conduct. 10 common audit observations, and closing. This is an important requirement to check during a compliance review. Next slide. What this reference covers. This reference is a single, comprehensive treatment of one topic, the pre-procurement conference. It draws together everything relevant to that one meeting, its legal basis, its purpose, who attends, what gets checked, what documents back up the check, how it applies or does not apply, to force account projects and to different modes of procurement, how it may be conducted virtually, and the audit findings it most commonly generates. Every citation has been checked directly against the full, official text of the implementing rules and regulations of Republic Act No. 12,009 and against the DPWH Department orders and COA issuances referenced throughout. Next slide. Section 1. Definition and purpose. What the pre-procurement conference actually is. In the government's own words and in plain terms. Next slide. Section 1.1. Definition. The pre-procurement conference is an internal meeting convened by the Bids and Awards Committee before the publication of the invitation to bid or request for expression of interest, to formally confirm that a specific procurement project is technically, financially, legally, and administratively ready to be exposed to the public bidding process. It is, functionally, a final internal quality check. A structured, documented moment where the BAC pauses and asks, in a disciplined way, whether everything that should already be finished actually is finished, before the point of no easy return, which is publication. Next slide. Section 1.2. Legal basis, the BAC's function to conduct it. Legal basis, IRR of RA number 12,009, Section 42. 1. C. The BAC shall have the following functions. C. Conduct pre-procurement and pre-bid conferences. Government personnel should follow this provision closely to avoid procedural defects. Next slide. Section 1.2. Why this placement in the law matters. Section 42. 1. C. Places the pre-procurement conference among the BAC's core, enumerated functions, in the same list as determining bidder eligibility, opening bids, evaluating bids, and conducting post-qualification. It is not an optional courtesy the BAC may choose to perform. It is one of the specific duties the law assigns to the BAC as an institution. This is worth noting because it means a BAC that never conducts a pre-procurement conference for any of its qualifying projects is not merely adopting a lighter internal practice. It is failing to perform one of its statutorily assigned functions. Next slide. Section 2. Legal basis and mandatory thresholds. The exact peso amounts that make this conference mandatory. Rather than optional, this rule is often a point of focus when verifying compliance with the law. Next slide. Section 2.1. Legal basis, the mandatory rule and its thresholds. Legal basis, IRR of RA number 12,009, Section 49. 1. Prior to the publication of the invitation to bid or request for expression of interest, the BAC is mandated to hold a pre-procurement conference on each and every procurement. However, the holding of a pre-procurement conference is optional for procurement of goods costing 5 million. 00 pesos and below, procurement of infrastructure projects costing 10 million. 00 pesos and below, and procurement of consulting services costing 2 million. 00 pesos and below. Next slide. Section 2.1. The three thresholds at a glance. Project type, mandatory above, ABC, optional at or below, ABC. Goods, more than 5 million Philippine pesos, 5 million Philippine pesos and below. Infrastructure projects, more than 10 million Philippine pesos, 10 million Philippine pesos and below. Consulting services, more than 2 million Philippine pesos, 2 million Philippine pesos and below. Next slide. Section 2.2. Reading the default rule correctly. Notice the structure of Section 49. 1. The default rule is that the conference is mandatory for each and every procurement, and the three thresholds are carved out as the exception, where it becomes merely optional. A common misreading treats the thresholds as if they were the starting point, with the conference mandatory only above them. The law is actually the other way around. Mandatory by default, optional only below the stated figures. Even where the conference is optional under these thresholds, a BAC may still choose to hold one, consistent with the same spirit found in Section 51. One's analogous rule for the pre-bid conference, where any prospective bidder may request one in writing, subject to BAC approval. Next slide. Section 2. Observation. Common audit observation. Issue 1. Mandatory pre-procurement conference skipped above the threshold. A procurement with an ABC above the applicable threshold, 5 million for goods, 10 million for infrastructure, or 2 million for consulting services, proceeded directly to publication of the invitation to bid without any pre-procurement conference having been held. Legal, regulatory basis, IRR of RA number 12,009, Section 49. 1. Next slide. Section 3. Why it matters. What this one meeting actually protects against, and why skipping it is costlier than it looks. Next slide. Section 3.1. The last internal checkpoint before publication. Once an invitation to bid is published, the project is exposed to the market and to the public. Correcting a defective ABC, an incomplete bidding documents package, or an unresolved award criterion at that point is far more disruptive than catching the same defect internally beforehand. It often requires a bid bulletin, a supplemental bid bulletin, or, in the worst case, a failed bidding and a full republication cycle. The pre-procurement conference exists precisely to catch these defects while they are still cheap and quiet to fix, before the cost of fixing them multiplies by becoming public. Next slide. Section 3.2. It protects 4 different interests at once. It protects the government's budget by confirming the ABC is real, current, and properly appropriated before the public is invited to bid against it. It protects the integrity of the competitive process by locking in the award criterion and specifications before any bidder can lobby to influence them once bidding is underway. It protects the contracting timeline, since a project that fails readiness review internally can be corrected in days, whereas the same defect discovered after publication can cost months through a failed bidding cycle. It protects individual BAC members and the procuring entity itself from audit exposure, since a documented, item-by-item readiness determination is direct evidence that due diligence was performed before public exposure of the procurement. Next slide. Section 4. The 4-point readiness determination. The actual substance of what the BAC checks, item by item, expanded in full. Next slide. Section 4.1. Legal basis, the 4 points, in full. Legal basis, IRR of RA number 12,009, Section 49. 1. C. During this conference, the participants, led by the BAC, shall determine the readiness of the procurement at hand, including, among other aspects, the following. 1. Availability of appropriations for the procurement activity in the GAA. Appropriation ordinance, corporate operating budget, or loan agreement. 2. Completeness of the bidding documents and their adherence to relevant general procurement guidelines. 3. Completion of the detailed engineering according to the prescribed standards in the case of infrastructure projects. And 4. Confirmation of the availability of right-of-way site or location, and the possession of affected properties, subject to Section 8 of this IRR. Next slide. Section 4.2. Point 1. Elaborated, availability of appropriations. This is the most fundamental check of all. Is there actually, legally, an approved source of funds for this specific procurement? For an LGU, this means confirming the specific line item in the enacted appropriation ordinance. For a national agency, it means the corresponding line in the General Appropriations Act or a continuing, automatic appropriation. For a foreign-assisted project, it means the loan agreement provision. A project can have beautiful plans, a perfect bill of quantities, and a fully drafted invitation to bid, and still fail this single check if the money behind it does not actually legally exist yet, has lapsed, or has been reprogrammed elsewhere. Next slide. Section 4.3. Point 2. Elaborated, completeness of the bidding documents. This checks the full 13-component bidding documents package required under Section 47. 1 of the IRR, the ABC, the invitation to bid draft, instructions to bidders, technical specifications, eligibility requirements, environmental criteria where applicable, plans or drawings, the bid form and bill of quantities, delivery schedule, bid security requirements, performance security and warranty terms, the contract form, and any additional documentary requirements. Adherence to relevant general procurement guidelines in this point is a deliberately broad phrase, meaning the BAC should also cross-check the draft documents against GPPB-issued standard forms, Philippine bidding documents templates, and, where applicable, GPPB circulars such as Resolution Number 10-2026 on documentary requirements for specific modes. Next slide. Section 4.4. Point 3. Elaborated, completion of detailed engineering. For infrastructure projects specifically, this checks that the full detailed engineering schedule under Section 8. 2. 1 of the IRR has actually been completed. Survey, site investigation, soils and foundation investigation, construction materials investigation, design plans, technical specifications, quantity and cost estimates, scope of work, and the proposed construction schedule. This point exists because Section 8. 1 of the IRR already prohibits bidding and award for an infrastructure project without duly approved detailed engineering. The pre-procurement conference is where the BAC independently confirms that prohibition has actually been satisfied, rather than simply taking the end-user unit's word for it. Next slide. Section 4.5. Point 4. Elaborated, right-of-way availability. This checks whether the land or site needed for the project is actually available, referring back to Section 8 of the IRR, which allows procurement to commence while right-of-way acquisition is still pending, but prohibits contract award until an authority or permit to enter, a notarized deed, or a writ of possession has been secured. The pre-procurement conference is the moment the BAC should ask, concretely, where the right-of-way process actually stands. Since a project that publishes an invitation to bid while right-of-way is entirely unresolved, risks reaching contract award with still no legal ability to actually access the site. Next slide. Section 4. Observation. Common Audit Observation. Issue 2. Readiness determination not documented item by item. The minutes state in general terms that readiness was confirmed, but do not separately and specifically address each of the 4 readiness aspects: appropriations, bidding documents completeness, detailed engineering, and right-of-way. Legal, regulatory basis, IRR of RA number 12009, Section 49. 1. C. Next slide. Section 4 Observation. Common Audit Observation. Issue 3. Appropriation cited does not match the actual enacted line item. The pre-procurement conference minutes cite a source of appropriation that, upon verification, does not correspond to any specific line item in the enacted appropriation ordinance. General Appropriations Act or Loan Agreement. Legal, regulatory basis, IRR of RA number 12009, Section 49. 1. C. 1. Next slide. Section 4 Observation. Common Audit Observation. Issue 4. Detailed engineering declared complete without supporting documentation. The conference declared the detailed engineering complete for an infrastructure project, but the procurement file lacks the supporting survey, soils investigation, or design plan documentation that would substantiate that declaration. Legal, regulatory basis, IRR of RA number 12009, Section 49. 1. C. 3, and Section 8. 2. 1. Next slide. Section 5. The remaining business of the conference. Everything else the back settles at this meeting, beyond the 4 readiness points. Next slide. Section 5.1. Legal basis, the full list of remaining business. Legal basis, IRR of RA number 12009, Section 49. 1. A, B, D, E, F. The participants, led by the BAC, shall a. Confirm the description and scope of the contract, the ABC, and contract duration. B. Ensure that the procurement is in accordance with the PPMP and app. D. Review, modify and agree on the criteria for eligibility screening, evaluation, post-qualification. Finally, determine whether the contract will be awarded to the LCRB, MIRB, MARB, or HRRB. E. Review and adopt the procurement schedule, including deadlines and timeframes. And F. Emphasize the importance of and agree on measures to ensure confidentiality, subject to Section 48 of this IRR, and the applicable sanctions and penalties. Next slide. Section 5.2. Point A. Confirming scope, ABC, and duration. This is a cross-check against the program of works and detailed estimate. Does the scope description in the draft bidding documents match what was actually engineered and costed? Does the stated ABC match the program of works figure exactly, to the peso? Does the stated contract duration trace back to an actual PERTCPM computation, rather than a round or arbitrarily chosen number of days? Any mismatch here is a red flag precisely because it suggests the bidding documents were drafted from a different, possibly outdated, version of the technical and cost documents. Next slide. Section 5.3. Point B. PPMP and app alignment. This confirms the project actually appears in the approved PPMP and the annual procurement plan, with a consistent ABC, mode, and schedule. Section 7. 8 of the IRR already makes an approved app a strict precondition for any procurement. This point is where the BAC affirmatively verifies that precondition is satisfied for this specific project, rather than assuming it. Next slide. Section 5.4. Point D. Finally settling the award criterion. This is one of the most consequential decisions made at the conference, whether the contract will be awarded on the basis of the lowest calculated responsive bid, the most economically advantageous responsive bid, the most advantageous responsive bid, or the highest rated responsive bid. This decision must be final by the end of the conference, because it determines the entire shape of the eligibility screening, the evaluation methodology, and the post-qualification criteria that follow. Drafting or publishing an invitation to bid before this is settled risks having to amend published documents mid-process, which invites both delay and legal challenge. Next slide. Section 5.5. Point E. Adopting the procurement schedule. This locks in the specific dates and deadlines for every remaining activity. Publication, the pre-bid conference if applicable, the bid submission deadline, bid opening. Evaluation, post-qualification, and eventual award, all of it consistent with the specific timelines fixed by sections 50 through 63 of the IRR. A schedule adopted here that is later found to be unrealistic, for example allowing too little time between posting and bid submission, is itself a compliance risk. Not merely a scheduling inconvenience. Next slide. Section 5.6. Point F. Confidentiality and sanctions. This reaffirms the confidentiality obligation under Section 48 of the IRR, discussed elsewhere in this series. No aspect of the bidding documents may be divulged to any prospective bidder or interested party before their official release, and only specifically authorized individuals. The BAC chairperson and members, the Secretariat, the TWG, and relevant end-user representatives may handle the documents before that point. The conference is where this obligation is formally reaffirmed to everyone present, along with the applicable sanctions and penalties for breach. Precisely because the risk of leakage is highest in the period immediately following the conference, while the bidding documents are being finalized. Next slide. Section 6. Attendees and Quorum. Who must be in the room, and the rule that determines whether the meeting can validly transact business. Next slide. Section 6.1. Who attends? The Bids and Awards Committee itself, as the body legally responsible for conducting the conference under Section 42. 1c. The Technical Working Group, where one has been created since Section 42. 1l. Allows the BAC to delegate technical review functions to a TWG drawn from technical, financial, or legal experts. The BAC Secretariat, which handles the administrative and documentary side of the conference. The end-user or implementing unit, since this is the office that actually prepared the technical specifications, the program of works, and the underlying justification for the project. Any consultants engaged by the procuring entity who prepared the draft bidding documents, since they are often best positioned to answer technical questions about the document's completeness. Next slide. Section 6.2. Legal basis, quorum for BAC meetings. Legal basis, IRR of RA number 12,009, Section 42. 2. A majority of the total BAC composition as designated by the Hope shall constitute a quorum for the transaction of business, provided that the presence of the chairperson or vice-chairperson shall be required. For purposes of determining a quorum, members of the BAC, which include the chairperson or the vice-chairperson, may be present, either in person or face-to-face through video conferencing, webcasting or similar technology for procuring entities with such technology. Next slide. Section 6.3. Why quorum rules apply to the pre-procurement conference. The pre-procurement conference is a BAC meeting and Section 42. 2's general quorum rule governs it exactly as it governs any other BAC meeting. A majority of the BAC's total designated composition must be present, and specifically, the chairperson or vice-chairperson must be among those present, regardless of how large that majority otherwise is. This has a direct practical consequence. A pre-procurement conference conducted with a majority of ordinary members present, but without the chairperson or vice-chairperson, has not validly convened, no matter how thorough the actual technical discussion was. Next slide. Section 6. Observation. Common Audit Observation. Issue 5. Conference held without a valid quorum. The pre-procurement conference proceeded and reached readiness conclusions despite the absence of the chairperson or vice-chairperson, or without a majority of the BAC's designated composition present, contrary to the specific quorum requirement. Legal, regulatory basis, IRR of RA number 12,009, Section 42. 2. Next slide. Section 6. Observation. Common Audit Observation. Issue 6. Award criterion left unresolved at the end of the conference. The pre-procurement conference concluded without a final determination of whether the award would be on an LCRB, MIRB, MARB, or HRRB basis. And the invitation to bid was subsequently drafted before this was settled. Legal, regulatory basis, IRR of RA number 12,009, Section 49. 1. D. Next slide. Section 6 Observation. Common Audit Observation. Issue 7. Conference held without the Technical Working Group or End-User Unit. The pre-procurement conference proceeded without the Technical Working Group or the End-User Implementing Unit in attendance. Despite their expected participation in the readiness determination and their first-hand knowledge of the technical documents being reviewed. Legal, regulatory basis, IRR of RA number 12,009, Section 49. 1. Next slide. Section 7. Step-by-step procedure. The full sequence of the conference from scheduling to the documented outcome. Next slide. Section 7.1. Pre-procurement conference, step-by-step, 1 of 2. Step 1. Confirm the threshold applies, check the ABC against the Section 49. 1. Thresholds to confirm whether the conference is mandatory. Step 2. Schedule the conference and notify attendees, BAC, TWG, Secretariat, End-User Unit, and any consultants who prepared the draft documents. Step 3. Confirm quorum, a majority of the BAC's designated composition, with the chairperson or vice-chairperson present. Step 4. Confirm scope, ABC, and duration, cross-check against the finalized program of works and detailed estimate. Step 5. Confirm PPMP and app alignment. The project and its ABC must already appear in the approved PPMP and app. Step 6. Work through the 4-point readiness determination, appropriations, bidding documents completeness, detailed engineering, and right-of-way, in that order. Next slide. Section 7.1. Pre-procurement conference, step-by-step, 2 of 2. Step 7. Resolve the eligibility, evaluation, and post-qualification criteria. Finally determine LCRB, MIRB, MARB, or HRRB as the award basis. Step 8. Adopt the procurement schedule, confirm deadlines and timeframes for every remaining activity, through contract award. Step 9. Reaffirm confidentiality, agree on measures to protect the bidding documents per Section 48, and the sanctions for breach. Step 10. Document the readiness determination. Minutes should address each of the 4 readiness points individually, not just in general terms. Step 11. Resolve any outstanding gaps before proceeding. If any readiness point fails, the project should not move to publication until it is corrected. Step 12. Proceed to finalize the bidding documents and ITB, only once every point in this sequence has been satisfied and documented. Next slide. Section 8. The complete readiness checklist. The actual documents behind each readiness point, consolidated from every stage. That feeds into this conference. Next slide. Section 8.1. Why this checklist is comprehensive, not just a summary. The 4-point readiness determination in Section 49. 1c is short in the law's own words, but each of its 4 points draws on a substantial body of technical and financial work completed earlier in the procurement cycle. This section consolidates that underlying work into one complete, practical checklist. Next slide. Section 8.2. Readiness Point 1. Appropriations, supporting documents. Document, what it confirms. Enacted Appropriation Ordinance, LGU, or GAA line item, national, the specific legal source of funds for this project. PPMP entry for the project. The project was planned and is ABC estimated at the planning stage. App entry for the project, indicative or final as applicable. The project has been consolidated into the entity-wide procurement plan. Certification of fund availability, where applicable. Budget officer confirmation that funds are actually available, not merely appropriated on paper. Next slide. Section 8.3. Readiness Point 2. Bidding documents, supporting documents. Document, what it confirms. Draft ABC, Item A, Section 47. 1. Traces to the finalized program of works and detailed estimate. Draft invitation to bid, instructions to bidders, Items BC, consistent scope, criteria, and schedule information. Technical specifications, scope of work, or TOR, Item D, consistent with the approved plans and detailed engineering. Eligibility requirements, Item E, correctly tailored to the mode of procurement and project type. Plans or drawings, Item G, the actual approved contract plans, not a draft or superseded version. Bid form, price schedule, bill of quantities, Item H, consistent with the DUPA and quantity sheet. Bid security, performance security, contract forms, Items JL, correct form and amount for the ABC involved. Next slide. Section 8.4. Readiness. Point 3. Detailed engineering, supporting documents. Document, what it confirms. Survey, site investigation, soils, foundation, materials investigation records, the engineering data behind the design actually exists. Approved design plans and contract plans, site development plan, plans and profile sheet, typical sections, drainage, structural plans. Quantity sheet, quantities are mathematically traceable to the plans, within the plus or minus 10% standard. Detailed unit price analysis, DUPA, unit prices traced to the current CMPD, standard labor rates, and ACEL guidebook. Certification of detailed engineering adequacy, the end-user unit, implementing unit, or consultant's attestation under Section 8. 6. Certificate of Validation and CMPD Utilization Certification, FY 2026 projects, per DPWH Department Order Number 01, Series of 2026. Next slide. Section 8.5. Readiness. Point 4. Right-of-way, what to confirm. For a fully acquired site, the deed of sale, deed of donation, or equivalent transfer document, duly registered where applicable. For a site where acquisition is still pending, an authority or permit to enter, a notarized deed, or a writ of possession, since Section 8. 1. One of the IRR allows procurement to proceed on this basis, while still prohibiting actual contract award until one of these is secured. Confirmation that no unresolved right-of-way dispute exists that would prevent physical access to the site once a contractor is engaged. Next slide. Section 8.6. The Complete Readiness Checklist, consolidated. Appropriations, Enacted Appropriation Ordinance, GAA line item, PPMP and app entries, and fund availability certification. Bidding documents, all 13 components under Section 47. 1. Internally consistent and matching the finalized program of works. Detailed engineering, complete survey and investigation records, approved contract plans, quantity sheet, DUPA, and the required certifications. Right-of-way, full acquisition or a valid authority to enter, notarized deed, or writ of possession. Scope, ABC, and duration confirmed consistent across the PPMP, app, program of works, and draft bidding documents. Award criterion, LCRB, MIRB, MARB, or HRRB, finally determined. Procurement schedule adopted, with realistic deadlines consistent with the timelines fixed elsewhere in the IRR. Confidentiality measures reaffirmed, consistent with Section 48. Next slide. Section 8. Observation. Common Audit Observation. Issue 8. Bidding documents package incomplete at the time of the conference. The draft bidding documents reviewed at the pre-procurement conference were missing one or more of the 13 components required under Section 47. 1. Yet the BAC still declared the project ready. Legal, regulatory basis, IRR of RA number 12,009, Section 47. 1 and Section 49. 1. C. 2. Next slide. Section 9. By administration, force account. What the term actually means, where it comes from, its current threshold, and how it connects back to the pre-procurement conference. Next slide. Section 9.1. Definition, by administration, is the official term. Force account is its synonym. Legal basis, GPPB Resolution Number 0182006, Annex A, Section 2. 1. By administration refers to the procedure by which the implementation of an infrastructure project is carried out under the administration and supervision of the concerned agency through its own personnel. Keep this requirement in mind, as it directly affects the validity of the transaction. Next slide. Section 9.1. Clearing up the terminology directly. Force account and by administration are the same thing. This is confirmed directly in the GPPB's own guidelines, which repeatedly use the phrase administration or force account together, treating them as interchangeable, not as two different arrangements. In plain terms, instead of hiring a private contractor to build an infrastructure project, the government agency itself builds it, using its own personnel and, where needed, its own or borrowed equipment. That is the entire concept behind both terms. Note that this specific guideline is written for infrastructure projects. Goods and consulting services do not have a parallel by administration concept in the same sense. Only construction work can be done in-house this way. Next slide. Section 9.2. Where RA number 12,009 itself recognizes by administration. Legal basis, IRR of RA number 12,009, sections 35. 2. 35. 5, and the takeover of contracts provision. 35. 2. In the case of infrastructure projects, the procuring entity has the option to undertake the project through negotiated procurement or by administration. 35. 5. C. Subcontracting is not allowed. However, the servicing agency may implement the infrastructure project in-house, by job order, or through the Procure contracting system. D. The servicing agency must have a track record of having completed or supervised a project, by administration or by contract, similar to and with a cost of at least 50% of the project at hand. Next slide. Section 9.2. 3 confirmed places, by administration, appears in the current law. Section 7. 1. At the PPMP stage, the procuring entity must simply state whether a project will require procurement or be undertaken by administration. Section 35. 2. Negotiated procurement, emergency cases. By administration is offered as an option specifically for genuine emergencies, alongside negotiated procurement itself or, in high security risk areas, implementation through the Armed Forces of the Philippines. Section 35. 5. Agency to agency, and the takeover of contracts provision. By administration also appears as an option when one government agency implements a project for another, or when a contractor's contract is terminated and no bidder remains willing to take over at negotiation. Next slide. Section 9.4. The threshold, as last amended. Legal basis, GPPB Resolution Number 0182006, Section 3. 3. As amended by GPPB Resolution Number 20-2020. Any project costing PHP 20 million pesos or less may be undertaken by administration or force account by the implementing agency concerned. A project costing over PHP 20 million pesos may be undertaken by the agency concerned only in specific cases, provided that prior authority shall be obtained from the Secretary of Public Works and Highways, if the project cost is PHP 20 million. 00 up to PHP 50 million. 00 pesos, or from the President of the Philippines, upon favorable recommendation of the Secretary of Public Works and Highways, if the project cost is more than PHP 50 million. 00 pesos. Next slide. Section 9.4. The threshold and approval chain, as last amended in 2020. Project cost, who may approve by administration. 20 million Philippine pesos or less, the implementing agency itself, no special approval needed. Above 20 million Philippine pesos up to 50 million Philippine pesos, prior authority from the Secretary of Public Works and Highways, and only for one of 5 specific cases. More than 50 million Philippine pesos, the President of the Philippines, upon favorable recommendation of the Secretary of Public Works and Highways. Next slide. Section 9.4. The 5 specific cases for projects above 20 million. Emergency arising from natural calamities, or where immediate action is necessary to prevent imminent loss of life or property. To comply with government commitments, as certified by the concerned government authority. Failure to award a contract after competitive bidding, for a valid cause. Termination or rescission of a contract. Areas with critical peace and order problems, as certified by the local Peace and Order Council. Next slide. Section 9.5. Track record requirement and the 2020 narrowing of DPWH validation. Legal basis. GPPB Resolution Number 018-2006, Section 3. 2. As amended by GPPB Resolution Number 20-2020. To undertake projects by administration, the implementing agency must a. Have a track record of having completed or supervised a project, by administration or by contract, similar to and with a cost of at least 50% of the project at hand, and b. Own the tools and construction equipment to be used or have access to such tools and equipment owned by other government agencies. The Department of Public Works and Highways shall validate criteria for evaluating the track record and capability of the LGUs as implementing agencies for nationally funded projects. Next slide. Section 9.5. A distinction the 2020 amendment specifically introduced. Before 2020, the guidelines could be read as requiring DPWH validation of track record and capability for any LGU undertaking a project by administration. The 2020 amendment narrowed this. DPWH validation is now required only for LGUs implementing nationally funded projects by administration. For a project funded entirely from the LGU's own local funds, this suggests the LGU has wider latitude in deciding to implement by administration, as an exercise of local autonomy. Without needing DPWH's prior validation of its track record, though the 50% track record and equipment access conditions themselves still apply. Next slide. Section 9.6. No subcontracting and equipment, tools must still be publicly bid. Legal basis. GPPB Resolution Number 018-2006, Sections 3, 4 and 3. 5. As amended by GPPB Resolution Number 20-2020. 3. 4. No contractor shall be used by the procuring entity, or its implementing agency undertaking infrastructure projects by administration, directly or indirectly for works undertaken by administration. 3. 5. Procurement of tools and construction equipment shall be subject to the rules on public bidding. This is a key provision that procurement officers must apply correctly. Next slide. Section 9.6. This is the basis for the point made earlier in this reference. Equipment and tools for a by administration project are explicitly, by name, subject to public bidding rules. This single sentence, Section 3. 5, is the direct confirmation that a force account project does not escape procurement law simply because the construction labor is done in-house. The tools and construction equipment the force account labor actually uses must still go through the ordinary public bidding rules, exactly like any other procurement. If that equipment or tools contract is pursued through competitive bidding and its own ABC crosses the Section 49. 1 threshold for goods, 5 million pesos, a pre-procurement conference is mandatory for that contract, on its own terms, regardless of the overall project being implemented by administration. Next slide. Section 9, continued. The labor component, in-house, job order, and PACUR. The 3 recognized ways force account labor is actually engaged. And the rules specific to each. Next slide. Section 9.7. Legal basis, the 3 labor arrangements. Legal basis, GPPB Resolution Number 0182006, Section 3. 7. The manual labor component of projects undertaken by administration may be undertaken in-house by the implementing agency concerned, by job order or through the PACUR contracting system. In-house labor is undertaken if the workers are employees or personnel occupying regular plantilla positions in the implementing agency. Job order contracts shall be governed by relevant Commission on Audit, COA, and/or Civil Service Commission, CSC, rules. Next slide. Section 9.7. The three labor arrangements, compared. Arrangement, who performs the work, governing rules. In-house, regular plantilla employees of the implementing agency, ordinary civil service employment rules. Job order, individuals hired for piece or lump sum work, or intermittent jobs of short duration not exceeding 6 months, on a daily basis. Relevant COA and Civil Service Commission rules. PACUR, a labor group hired for a specific work, service, with tools and materials furnished by the agency, GPPB Resolution Number 0182006, Section 4. 0, detailed in the next slides. Next slide. Section 9.8. Definition, PACUR. Legal basis, GPPB Resolution Number 0182006, Section 2. 6. PACUR refers to a system of hiring a labor group for the performance of a specific work and/or service incidental to the implementation of an infrastructure project by administration whereby tools and materials are furnished by the implementing agency. For the specific work, service output, a lump sum payment is made either through the group leader or divided among the PACUR workers and dispersed using a payroll system. Next slide. Section 9.8. The key feature that distinguishes PACUR from an ordinary contractor. In a PACUR arrangement, the government supplies the tools and materials. The PACUR group supplies only labor, for a specific, defined scope of work, paid as a lump sum. This is precisely why Section 4.7 of the Guidelines expressly disqualifies any PACUR group that is, or is organized by, a regular or licensed contractor, since a licensed contractor bringing its own tools, materials, and management is no longer performing PACUR labor, it is functioning as an actual contractor, which Section 3.4 already prohibits for by administration work. Next slide. Section 9.9. Recruitment, competitive selection, and the peso cap. Legal basis, GPPB Resolution Number 0182006, Sections 4. 1, 4. 4, and 4. 8. 4. 1. Unskilled labor should be drawn from the barangay where the project is located. Semi-skilled labor shall be recruited within the municipality, preferably within the barangay. Skilled labor shall be recruited within the province but preferably within the barangay, municipality. 4. 4. Where there is competition for the award of PACUR works, the PACUR labor contract shall be awarded through competitive selection with at least 3 PACUR groups participating. The winners shall be determined based on what groups undertakes to deliver the desired output at the lowest rate. 4. 8. The amount of a PACUR labor contract per project shall not exceed P500,000. 00 pesos per PACUR group. Next slide. Section 9.9. 3 numbers worth remembering. Recruitment tiers. Unskilled labor from the barangay itself, semi-skilled from the municipality, skilled from the province. Always preferring the most local source available at each skill level. Competitive selection threshold. At least 3 PACUR groups must participate whenever there is genuine competition for the work, selected on a per output, lowest rate basis. The peso cap, 500,000 pesos per PACUR group, per project. This is a hard ceiling on each individual group's contract value, not on the project as a whole, since a large project may engage several PACUR groups simultaneously, each within its own 500,000 peso limit. Next slide. Section 9.10. By administration, force account readiness checklist. SB, SP resolution, or equivalent HOPE approved documentation, confirming inclusion in the app. Including the procurement of tools and construction equipment as a distinct component. Track record documentation, a prior project, by administration or by contract, similar to and costing at least 50% of the current project. For LGUs on nationally funded projects specifically, DPWH validation of that track record. Confirmation the implementing agency owns, or has documented access to, the required tools and construction equipment. No contractor engaged, directly or indirectly, for the works themselves. Tools and construction equipment procured through ordinary public bidding rules, including a pre-procurement conference if that specific contract's ABC crosses the Section 49. 1 threshold. Labor arrangement documented as in-house, job order, 6 months or less, or PACURE, with group leader, competitive selection if applicable. And the 500,000 peso per group cap respected. Next slide. Section 9 Observation. Common Audit Observation. Issue 9. Equipment or tools procured without public bidding for a by administration project. Tools or construction equipment for a project being implemented by administration were acquired directly, without following public bidding rules. Contrary to the explicit requirement that this specific component remains subject to competitive procurement. Legal, regulatory basis, GPPB Resolution Number 018-2006, Section 3. 5 Next slide. Section 9 Observation. Common Audit Observation. Issue 10. Equipment, tools contract crossing the threshold skipped its own pre-procurement conference. A by administration project's equipment or tools contract, procured through competitive bidding with an ABC above the 5 million peso goods threshold. Proceeded to publication without a pre-procurement conference, on the mistaken assumption that the project's overall by administration status exempted it. Legal, regulatory basis, IRR of RA number 12,009, Section 49. 1. GPPB Resolution Number 018-2006, Section 3. 5 Next slide. Section 9 Observation. Common Audit Observation. Issue 11. A contractor was used, directly or indirectly, for work labeled, by administration. Evidence suggests that a private contractor performed some or all of the actual construction work on a project officially classified as by administration. Contrary to the explicit prohibition against using any contractor for such works. Legal, regulatory basis, GPPB Resolution Number 018-2006, Section 3. 4. As amended by GPPB Resolution Number 20-2020. Next slide. Section 9 Observation. Common Audit Observation. Issue 12. PACURE contract exceeded the 500,000 peso per group cap. A single PACURE group's labor contract for a project exceeded the 500,000 peso ceiling fixed for that specific arrangement, without the work being properly divided among additional groups within their own individual caps. Legal, regulatory basis, GPPB Resolution Number 018-2006, Section 4. 8 Next slide. Section 9 Observation. Common Audit Observation. Issue 13. Track record or equipment access condition not documented before using by administration. An implementing agency proceeded with a by administration project without documented evidence of the required track record. A prior similar project costing at least 50% of the current one, or of owning or having access to the necessary tools and construction equipment. Legal, regulatory basis, GPPB Resolution Number 018-2006, Section 3. 2. As amended by GPPB Resolution Number 20-2020. Next slide. Section 10. Applicability by mode of procurement. Beyond by administration, does this conference apply to every mode of procurement, or only some? Next slide. Section 10.1. The modes this conference is built for. Section 49 sits within the part of the IRR governing competitive bidding and the closely related competitive selection modes. The same family of modes that lead to an invitation to bid under Section 50. Read in that structural context, the pre-procurement conference is understood to apply to competitive bidding, competitive dialogue, limited source bidding, and unsolicited offer with bid matching, all of which culminate in an ITB. Small value procurement, direct contracting, and most grounds of negotiated procurement instead use a request for quotation sent directly to a small number of identified parties. Never an invitation to bid, and structurally do not pass through the Section 49 conference mechanism at all. Next slide. Section 10.2. Applicability, mode by mode. Mode of procurement, pre-procurement conference applies. Competitive bidding, yes, subject to the Section 49. 1 thresholds. Competitive dialogue, yes, subject to the Section 49. 1 thresholds. Limited source bidding, yes, subject to the Section 49. 1 thresholds. Unsolicited offer with bid matching, yes, subject to the Section 49. 1 thresholds. Small value procurement, no, uses the RFQ mechanism, not an ITB. Direct contracting, no, a single identified supplier, no competitive process to prepare for. Most negotiated procurement grounds, no, direct negotiation or RFQ to identified parties. Next slide. Section 10.3. A practical decision sequence. First, identify the mode of procurement actually being used for the specific transaction in question, not the label of the overall project. Second, if the mode is competitive bidding, competitive dialogue, limited source bidding, or unsolicited offer with bid matching, check the ABC against the Section 49. 1 thresholds. Third, if the ABC exceeds the applicable threshold, the pre-procurement conference is mandatory. If it does not, it is optional, at the BAC's discretion. Fourth, if the mode is small value procurement, direct contracting, or negotiated procurement, no pre-procurement conference is required by Section 49. Regardless of the ABC involved. Next slide. Section 10. Observation. Common audit observation. Issue 14. Pre-procurement conference requirement misapplied to a non-competitive mode. A BAC either incorrectly required a pre-procurement conference for a small value procurement or direct contracting transaction, adding an unnecessary step, or incorrectly assumed a competitive bidding transaction was exempt because it resembled a smaller, informal purchase. Legal, regulatory basis, IRR of RA number 12,009, Section 49. 1. Section 26. 1. Modes of procurement. Next slide. Section 11. Virtual and electronic conduct. Whether, and how, the pre-procurement conference may be held through video conferencing rather than in person. Next slide. Section 11.1. Why this deserves full treatment here. The pre-procurement conference has no separate, standalone provision on virtual conduct, unlike the pre-bid conference, which has its own explicit rule in Section 51. 3. Or bid opening, which has its own explicit rule in Section 58. Instead, because the pre-procurement conference is fundamentally a BAC meeting, it is governed by the IRR's general rule on electronic BAC meetings. Next slide. Section 11.2. Legal basis, the general rule for electronic BAC meetings. Legal basis, IRR of RA number 12,009, Section 42. 3. Meetings of the BAC may be conducted electronically for procuring entities with video conferencing, webcasting, or similar technology capability. The decision of at least a majority of those present, either in person, face-to-face through video conferencing, webcasting, or similar technology, or a combination thereof. At a meeting at which there is quorum shall be valid and binding as an act of the BAC. Next slide. Section 11.2. The 2 conditions that actually matter. First, a genuine technology precondition. The rule only applies for procuring entities with video conferencing, webcasting, or similar technology capability. A procuring entity that does not actually have this capability cannot validly claim to have held an electronic BAC meeting. The rule is not a general permission to meet, however, is convenient. It is conditioned on real technical capacity. Second, the quorum rule from Section 42. 2 still applies in full. A majority of the BAC's designated composition, including the chairperson or vice chairperson specifically, must be present. Whether that presence is in person, through video conferencing, or a mix of both. Next slide. Section 11.3. A hybrid meeting is explicitly contemplated, not just fully virtual or fully in person. The rule allows in person, face-to-face through video conferencing, or a combination thereof. This is worth emphasizing precisely because it is often overlooked. The IRR does not force a binary choice between a fully in-person conference and a fully virtual one. It expressly contemplates a combination, some BAC members attending physically, others joining electronically, at the same session. The validity of any decision made still depends only on whether a proper quorum, computed across however many attended in each mode, was actually present. Next slide. Section 11.4. How this interacts with the rest of the series. The pre-bid conferences virtual rule, Section 51. 3, is stricter than this general rule, since it requires that the market participants attending, not just the procuring entity, also have video conferencing capability. Because that conference is public-facing. The pre-procurement conference, being purely internal to the BAC, TWG, Secretariat, and end-user unit, does not carry that same market-facing condition. Only the procuring entity's own technology capability needs to be genuine, since no external bidder participation is contemplated at this stage. Next slide. Section 11.5. Conducting a virtual or hybrid pre-procurement conference, step by step. Step 1. Confirm actual technology capability, genuine video conferencing or webcasting capability, not merely a stated intention to use it. Step 2. Schedule and notify as usual, the same notice to BAC, TWG, Secretariat, and end-user unit as an in-person conference. Step 3. Confirm quorum across attendance modes, majority of designated composition, chairperson or vice chairperson present, in person or electronically. Step 4. Conduct the same 4-point readiness determination, nothing about the substance of the review changes because it is virtual. Step 5. Record the session, retain a recording or webcast log alongside the written minutes. Step 6. Document attendance mode for each participant, note who attended in person versus electronically, relevant to any future quorum verification. Next slide. Section 11.6. Virtual Conduct Checklist. Procuring entity genuinely possesses video conferencing, webcasting, or similar technology capability. Quorum confirmed and documented, including the chairperson or vice chairperson's presence, whether in person or electronic. All 4 readiness points, and the remaining business items, addressed exactly as they would be in an in-person conference. Recording, webcast log, or equivalent retained alongside the written minutes. Attendance record distinguishes in-person from electronic participation for each individual. Next slide. Section 11 Observation. Common Audit Observation. Issue 15. Electronic conference claimed without genuine technology capability. A procuring entity conducted, or claimed to conduct, a pre-procurement conference electronically without actually possessing video conferencing or webcasting capability. The specific precondition Section 42. 3 attaches to any electronic BAC meeting. Legal, regulatory basis, IRR of RA number 12,009, Section 42. 3 Next slide. Section 11 Observation. Common Audit Observation. Issue 16. No recording retained for a virtually conducted conference. A pre-procurement conference conducted virtually or in hybrid format left no recording or webcast log on file, only written minutes. Leaving no independently verifiable record that the electronic session actually occurred as claimed. Legal, regulatory basis, IRR of RA number 12,009, Section 42. 3. By analogy to the recording expectations applied elsewhere in the IRR, such as Section 51. 4. For pre-bid conferences. Next slide. Section 12. Closing summary. Pulling the entire pre-procurement conference together into one final, working reference. Next slide. The 16 observations, consolidated. Mandatory conference skipped above the threshold. Readiness determination not documented point by point. Appropriation cited does not match the actual enacted line item. Detailed engineering declared complete without supporting documentation. Conference held without a valid quorum. Award criterion left unresolved at the end of the conference. Conference held without the TWG or end-user unit. Bidding documents package incomplete at the time of the conference. Equipment, tools procured without public bidding for a by-administration project. Equipment, tools contract crossing the threshold skipped its own conference. A contractor was used for work labeled by administration. Pack your contract exceeded the 500,000 peso per group cap. Track record or equipment access condition not documented. Conference requirement misapplied to a non-competitive mode. Electronic conference claimed without genuine technology capability. No recording retained for a virtual conference. Next slide. Section 12.2. The single idea behind all 16. Every one of these 16 observations traces back to the same root cause, treating either the pre-procurement conference or the by-administration framework itself as a formality to be logged, rather than as the substantive readiness and accountability check both were actually designed to be. A conference that genuinely works through all 4 readiness points, with a valid quorum, a documented and specific record, the correct threshold and mode applied. The by-administration rules correctly separated from the underlying procurement rules that still apply to materials and equipment, and, where used. Genuine and properly recorded electronic participation is very difficult to fault on audit, precisely because it does exactly what the law asks of it. Next slide. End of guide. The pre-procurement conference is where readiness is proven, not assumed. Whether the project is by contract or by administration, whatever mode of procurement is in play, and whether the conference is held in person, virtually, or as a hybrid. The same substantive question governs: is the appropriation real, are the bidding documents complete, is the engineering finished, and is the site actually available? Answering that question honestly, on the record, is the entire purpose of this meeting.